want to first, before Hannah does some housekeeping, what I want to say first is thank you all for your grace in showing up today. We planned to do this 2 weeks ago, as many of you who were registered for a while know. And as sometimes happen, life happened that week, and it was at the last minute, and it was unexpected and unavoidable. And so thank you for hanging in and giving us some grace to reschedule. And we're excited to have this conversation today.
It's going to be great. And I think even better, it's like instead of an appetizer, it's like dessert.
Well, hopefully it gave everybody 2 extra weeks to think about questions that they wanted to bring.
There you go. Okay, so let's go ahead and dive in. Hello, everyone, and thank you so much for joining us. My name is Hannah Roth, and I work with Predictive ROI. I'll be helping to moderate the Q&A session today. So as Sharon mentioned, before we begin, I just want to go through a few housekeeping items. So number one, if you haven't already, please go ahead and put yourself on mute so we don't have any distracting noises or background noises. As you guys can see, there's going to be a few people on the call today, so we want the sound to be as clear as possible for everyone. Number two, the session is going to be recorded. So if there are questions that you prefer to ask in private, please email them to kayla@legalandcreative.com, and I will go ahead and send that into chat for you if you have any questions that you don't feel comfortable asking with the session being recorded or asking in front of others. So Kayla's info is there. Next, the format for this Q&A, just so we all know what to expect. It's going to be about 15 to 20 minutes of fast-paced teaching where Sharon's walking us through some of the insights that she has for today. And then we're going to open up the floor for about 40 to 45 minutes to answer your specific questions. That said, feel free to ask questions as we go. You don't have to wait for the allotted time. If something pings in your mind and you say, oh, I would really like to ask this question, please go ahead and add it to chat. And then Heather and I will be taking notes so that way we make sure that we get to as many questions as we can today. That said, odds are good that we may not get to every question that you guys have, but for the questions that Sharon doesn't get to answer, we're hoping to reach out via email with some of those. So if you can't, please turn your video on. It's a lot more fun to talk with people and with each other than to stare at blank screens. So if you're not engaged in something else or if you have the capability, please go ahead and turn your cameras on. And then lastly, and maybe most importantly, please do not be afraid of asking quote unquote dumb questions. The whole purpose of this is a Q&A, question and answer, and we want you guys to learn as much as possible. And if you've been to one of these before, I always like to say that Sharon got a law degree on purpose, so the rest of us didn't have to. So please don't feel shy about asking your legal questions and advice. So that wraps up the housekeeping. And now I want to move into introducing you to our wonderful host, in case you guys don't know her, Sharon Torek. So for those of you meeting Sharon for the first time, she is an intellectual property and marketing law attorney. She specializes in helping agencies avoid the sticky wickets that we sometimes get ourselves into. But that's not all. Sharon also helps agencies protect and monetize their IP, which opens up new revenue streams. And most of the time, we're often unaware of some of the monetization that can happen with our IP. So everybody likes more money, right? So Sharon's a great person to talk to concerning that. She is also a regular guest speaker for Agency Management Institute. So I know that some of you that attended the Build a Better Agency Summit last month got to see Sharon speak, which was fantastic. She is also the former president of the American Ad Federation of Cleveland, and she serves on the legal consultant panel for the American Association of Advertising Agencies, better known and more easily said as the 4As. Yep. Sharon regularly consults on the topics of intellectual property, like I mentioned. She's also an expert at, artificial intelligence and the different landscape, when it comes to legalities around AI. She's an expert on marketing agency relationships, setting yourself up for success in that way. And then also the legal gymnastics that sometimes comes from social media campaigns and things like that. So again, as a lawyer specializing in agencies, she's a wealth of information. So for today's session, Sharon's going to be discussing how to get your money from clients and avoid delayed payments and cash flow squeezes, which every agency owner can surely benefit from. So without further ado, it is my pleasure to introduce you guys to Sharon. So
Thank
Sharon.
you, Hannah. I really appreciate it. Yeah, I'm looking forward to this topic because it is it's so frustrating for us as advocates for agencies when a client comes to us and they have worked really hard to bring a new piece of business in, a new client or a new project with an existing client. They've done great strategic or creative work. They've spent a lot of time concepting the campaign, and then they have a payment problem. So it has cost them money to acquire the client or the piece of business. It has cost them lost time, lost opportunities, and therefore money to create the work. And now they've got to fight for their money. And it can feel like there's not a lot of great options sometimes for agencies. And so let me get my slideshow started just a second. There we go. It can feel like there's not a lot of great options, either immediately escalating it to legal procedure can feel like overkill. It will definitely throw a wrench in an existing relationship that you may want to still preserve for other reasons. And so the goal today is to really think systemically about your money and specifically the money that clients owe to you. And we're going to do that in 3 parts. And we are going to move at a pretty fast clip because the primary goal of today is to get us to all learn from one another's questions and the conversation that ensues from that. So we're going to talk about payment models. And a lot of this will definitely be review for you, but I've included it in today's session because despite the fact that you intellectually understand these to be options for you, we don't see enough agencies executing on some of these options. And they could be stopgap solutions for avoiding problems in the first place with your accounts receivable. Then we're going to talk briefly about the types of contractual language you want to have in your master services agreement or your client terms and conditions and your statement of work that deals with your payment policies and translates those policies into obligations that the client has to you or commitments they make to pay you. And then those are sort of the preventative measures we will discuss. We're going to talk about some options for you to consider if something does go sideways with a client receivable. How can you manage it internally? What are some of the escalation levers that you might pull? What are some actual practical steps that you can take as an agency to deal with this, hopefully before it has to escalate too far and cost you lost time, money, and other resources. So let's talk foundationally at a high level about your agency's legal security, its financial security. You know, your success in resolving accounts receivable or invoicing issues with the client really comes down to one of your most critical legal pillars for the agency, and that is your client terms or your master service agreement. We have sort of themed these Q&A sessions that we do 4 times a year around other essential pillars for your agency's success, things like mutual non-disclosure, independent contractor agreements, agency to agency, strategic alliance agreements. Your success in all of these relationships and transactions for your agency so hinges upon the way your contracts are written and whether or not you've left yourself options in your contract documents in case a problem arises later. So I want you to just be thinking about that at a foundational or systemic level for your agency. With that said, let's start with agency payment models. These are things for you to think about the way you structure the payment expectations that you have of your client and the way the funds flow from the client to you. So your goal here is to make AR irrelevant to your agency. At the end of the day, what we want to see happen is for you to have to spend as little time on the actual collection of the money. It's not going to take away the billing function of your team. You're still going to have to account for time. You're still going to have to send an accounting in a bill form or something to your clients. But to the extent that you can make the actual collection of the money irrelevant with some of your payment models, it's worthwhile consideration to try to implement. One of those options is advance payments. And I can sort of feel the mental eye rolling on this one at the moment. You're probably thinking, yeah, we know we can charge the client in advance. But not enough of you are doing it, in my opinion, based on the number of agency owners that we've talked to over the years and the number of agreements we've seen over the years. More of you have opportunity to actually eradicate some of your AR issues by billing only in advance and never leaving any collection risk on the table. So I want you to think long and hard at the end of today's session about how you could be modeling the way your clients pay you to never have to worry about billing them afterward for work you've already done. Some of you, many of you, put your clients on retainer models. Some of you have subscription models. Those of you who don't, think about creative ways you can institute either of these in your client relationships. And then project fees that are paid before you start. And I don't see enough of this. I see sometimes a deposit. I see sometimes as a portion of the payment, but then you're left holding the bag because you've either got to deliver the work and wait to be paid or get into a stalemate with your client later when you haven't set the expectation in the beginning. So pay attention to this. Excuse me. I know that you know that these are options, but really think hard about how you can actually implement them into some of your client relationships. Close cousin to this is phase or milestone payments. I think that it's a very easy default, not just in the agency space, but any professional service business, ours included, to think about just accounting for the amount of time that you spend to serve a client, and then have everybody settle up after the work or a portion of the work has already been done. But if you think strategically ahead of time about the milestones or the stages of a project or the stages of a long-term relationship that you're going to have with a client, you kind of know when the biggest tranches of the work are going to be coming. You might be working on a sprint methodology, or you may have very clearly defined phases of the project in your original proposal or estimate. I want you to think about tying those very closely to milestone payments so that you are never getting over your skis in terms of getting paid when I hear this a lot. The most amount of time we spend on getting up to speed with this client, getting their work done, is at the beginning. So maybe that's the phase that your advance payment or milestone payment should be the largest for. Or for some of you, it's getting the project across the finish line at the end. Or for some of you, there's seasonality to the work that you do. Think creatively and strategically at the beginning of the work relationship between agency and client about when is our work most likely to be intense, and let's set the milestone payments for advance payment accordingly. And again, I know these things are not rocket science, but we don't see as many agencies actually implementing these things as I would like to. And I think your AR headaches would be significantly lesser if you did. All right, what a bifurcated, or what I call a split payment, is to think about your billing cycle for the client in 2 stages. And hear me out. I know this feels like a headache on the face of it, but think about those expenses that are necessary to fulfillment of the work scope with the client, like media buys, production costs that are done for work done by third parties, anything that is out of pocket. And think about accounting for or running dual billing cycles for clients where these are going to be significant, and billing in advance for those expenses, or having clients pay them directly to the vendor, and billing for your fees if you choose to in arrears. At least this way you are not out of pocket for cash, in addition to having to wait to collect your fees for service. So if you're unwilling to bill in advance for fees, then thinking about a split payment cycle for your clients where it makes sense given the nature of the work you're going to do is something to think about implementing. And it's also a little bit more palatable in our experience to most clients because they understand that out-of-pocket expenses are just something that you can't be expected to finance for them. Not all of them will love it, but most of them understand it. A lot of you do retainers. A lot of you are not truing up with your clients on a regular enough basis to those retainers. And so whatever that means for you and the work cycle of the project you're engaged in for the client, if a quarterly true up makes sense, given the kind of work you're going to do and the cycles of production that will occur, that's fine. Sometimes a true up needs to occur every other month. Sometimes 6 months is okay. The point is to be thinking strategically at the beginning about when are you going to look at the difference between what you've been charging the client on a retainer basis and the actual amount of effort extended or value extended to the client. For those of you who do value billing, then this is not as big an issue because your value has been pre-established and you've, supposedly or hopefully really sharpened your pencil at the beginning to determine what a reasonable profit margin is and what good value represents for the client for the fee investment that they're making. And so the true up is not as critical. But for those of you who maybe have not done that, or where the scope is not as well defined, or where the scope expands, a lot of problems with accounts receivable between agencies and clients end up happening because the scope changes. It gets broader, or a project gets abandoned and replaced with another project, and the parties haven't adequately rescoped what that will mean for the fees. And therefore, there's a misunderstanding or a disconnect when the bill gets sent about what it was going to cost and which money gets allocated to which project. So true ups are important for all of those reasons. Rush fees. I'm a big proponent of agencies thinking hard about what their policy is for rush work. What does a rush mean to you? And does it mean the same thing to you for each client? You may have priority clients for whom a 24-hour request is just part of the expectation you had when you started to work with them. This would be particularly true for PR agencies who do things like crisis work, etc. So for you, you have probably built in a certain amount of on-call expectations or quick turnaround expectations into your fees to begin with. But for those of you who haven't necessarily built this in, or for whom this would be unusual, you need to be thinking about what do you charge a client who wants or asks for express turnaround for a particular project or thing. So think about it internally with the team, with the production team, the creative team, the account team. What does it mean for this client? Or do we have one standard rush policy and it applies across the board to all of our clients? I don't have opinion about which way you should go. You know your agency's dynamics best, but you should have a policy, and that policy should be reflected, as we'll see later, in your contract, and then you should be enforcing it. So if a client asks for rush work, then you ought to be invoicing them for that either immediately with an electronic payment mechanism, or it needs to be showed up in your next invoice, and that invoice should not be 30 or 60 days out from getting to them. My experience is that the sooner you invoice a client after you actually perform the work for them, the higher the likelihood of you getting paid 100% of the fees that are in that invoice. So decide what your rush policy is going to be, document it internally so that everybody's got a level set around it, and then reflect it in your agreements. Restart or dormancy fees are important for you to hold clients accountable when there are delays in providing necessary information, providing approvals that you need, agreeing on the kickoff date of a project when they are sitting on their thumbs and you're waiting to go and you have bandwidth allocated on your team and nothing's happening. So again, think internally about what your kickoff date intentions are for a relationship or a piece of work. Have the communications with your client to make sure everybody's on the same page, and document the start dates or the phase dates in your statement of work if you think that's appropriate. But have an expectation and have a communication of that expectation. And then document your policy for when that expectation is not met. In other words, we haven't heard from you in 30 days. We're going to have to assess you a restart fee to look at your documents again, have another project kickoff meeting, whatever it means for the kind of work that you do. Think about what is reasonable in the scope of your fee relationship with the client or your intended fee relationship, and institute a dormancy or restart fee, because the stop start creates a definite cost and administrative burden on your agency, and that should be reflected in your fee policies. Kill fees. We don't see these frequently, but they are important for those of you who have entered into long-term agreements with clients with an expectation that you will stage the receipt of fees from the client over a somewhat long period of time. Think 12 months, it's a good example. And they stop the project after month 4 or month 5 or month 6. And the other half of the revenue you were expecting to get from that client for the year ends up being in the ether. So kill fees are intended to sort of pre-establish the financial consequences to the client of them terminating work that the parties agreed was going to be consistently performed throughout a long period of time, along with the payments associated with that. So it can work for a single project if the project fee is predefined. It can work with a minimum contract term that is longer in length, think at least 6 months. And I'm going to give you the standard benchmark here. I can tell you that this is not universally applied. Sometimes it's higher, sometimes it's lower, but think 50% of the remaining anticipated fees that you would have charged had the work not been canceled. That enables you to reallocate that bandwidth to other either business development or client service activities for other clients, without taking a complete haircut on the work you were expecting to do for this client. So think about kill fees if they fit the kinds of engagements that you work on with your clients as an agency. All right, so our goal there was payment structures that help us avoid AR. Now I want to talk really briefly about the contract terms that I want you to be focusing on in your client services agreements that impact your ability to collect fees later, and also set the table with your client a lot more specifically about your payments. Again, I want to just think at a higher level for a moment about the master service agreement or your client service agreement. A lot of times we see bleeding between the statement of work and the MSA about payment terms, work description terms, deadlines, things like that. This is a rule of thumb I want you to keep in mind. Some of the provisions that will universally apply to all your clients regarding payments, like interest, late fees, rush fees, that kind of thing, those things can go into your standard master terms. But details related to specific dollars, deadlines, deliverables, those are the very specific things about the piece of work you're actually going to be doing for the client. Those are best and served by being in your statement of work, because you really need flexibility to have different fee schedules, different project deadlines, different deliverable definitions. You may have multiple statements of work with a single client. So it is best to throw those 3Ds in that statement of work. Sometimes you'll see them in the estimate and proposal versus the MSA. So this is a drafting tip for you, or to share with your legal counsel. And then the other thing I want you to be thinking about is that some of your, as I said earlier, some of your payment provisions in the contract with the client need to be backed up by internal written policies in the agency, so that everybody's on the same page about things like rushes and dormancy, et cetera. Okay, your goal before, avoid an account receivable at all. Your goal here, leverage, so that if a payment dispute happens, you have places in the contract that serve as your leverage points and collection of your money. All right. My favorite one, and one we have employed to success for agencies here at the firm, is IP transfer timing. Your client has an expectation, for the most part, that they're going to own the rights to the work that you do for them. And generally, there are lots of exceptions, but this is not an IP workshop. So I'm going to remind you that they should never, ever attain the rights to the work that you do for them until you've been paid in full. So no money, no transfer. Secondly, if you're retaining some of your IP and only licensing it to them, what are some examples of that? Software that is proprietary to you, that you incorporate into a deliverable, content libraries that you access that are yours, that you provide to more than one client, etc. Make sure that that is reflected in a license provision or a license agreement, and then may even have a separate revenue stream. So again, I don't want to get us diverted into that, but the main point here, no money, no transfer of rights. All right, payment timing. This is something I want you all to be thinking about if you work with the types of clients who require you to sign their agreement. Their default provisions will contain a lot of exceptions to the standard payment terms that you have agreed upon. Agencies are really good about being clear about their payment terms. We need to get paid in 15 days, 30 days, 40 days. With this client, it's 30. With this client, it's 60. A lot of it is dependent upon the type of client you work with. A lot of it is dependent upon the size of the client you work with. The larger the client, the more likely you will see exceptions to when the time starts running on when an invoice payment is due. Your language should say in your agreement, the clock starts ticking when we send you our invoice. Their agreement might say something like, the clock will start ticking when we approve your invoice, which could take another 10 or 15 days. So turning a 30-day term into a 45-day term. The clock might start ticking when we've resolved all questions, disputes, or other issues relative to your invoice. How long will that take? And what is the escalation procedure there? So these are things that I want you to be watching out for in the client's agreement, and that I want you to be clear on in your agreement, that the time starts once the bill gets sent. All right, interest and late fees. If you want an opportunity to ever collect interest or late fees from a client who is not timely paid you, it must be in writing in your agreement. No court will enforce it if it is not. Even though the fair thing to do would be to pay you a fair amount of interest if you had to wait for your money. No writing, no interest, no late fees. So please make sure you're specific about this in your agreements, and to give yourself the lever to be able to pull later. Same with collection costs and attorney's fees. If you have escalated to the point of having to litigate with your client about a bill, I hope you never get there, because by then, for certain, the relationship is trashed. And you've also probably spent a lot of time trying to resolve things informally. But some of you will have no choice. If you want to be able to collect your collection costs, your attorney's fees, and recover those amounts, again, that's got to be in your contract, or no court will award it to you. Work suspension. This can be powerful, particularly for a client who's got a time-sensitive need, or for whom you're working on a major initiative that's relevant to a key business goal that they have. If you don't pay us in a timely manner, we will stop working. And you've got to have a lot of steel reserve for this to be effective, though. You have to really be willing to stop working. And it's sometimes something agencies are reluctant to apply upfront. Sometimes they want to have made a number of attempts to try to move the payment problem along, because they don't want to lose the leverage of the work they've already done or the momentum they have on the project. But it can be a very effective measure, but it's got to be in your contract again and accompanied with it, some internal standards about communications and what your policy is about how many times will we ask for our money before we stop work. What will our contracts say about how long we're willing to wait for our money before we will exercise our option to stop work? So be thinking about your philosophy around that and make sure it's reflected in your documents. All right, things we talked about: special payment rules, rush fees, dormancy, restart fees. These definitely need to be in your contract. So these are as essential to your agreement as things like interest or attorney's fees collections. All right, so we've talked about avoiding AR altogether. We have talked about contract terms that minimize the likelihood of AR, hopefully, or serve as leverage if you need to enforce payment. Now, let's talk about some things for your agency to do independently to try to resolve payment disputes on your own. Your goal here: solve the problem yourself without legal intervention, hopefully, or with minimal legal intervention. I like to suggest a graduated approach. It's going to probably take you more than one attempt to resolve an invoice dispute on your own. So I want you to think of these as stair steps, and you probably won't need all of them, or you may, or they may not be enough. So I'm going to give you kind of the stair-stepped approach that we recommend to you, and just give you the caveat up front that you may not need all of these steps. I hope you don't, but they're there. They are a gradual application of pressure on the client to encourage them to resolve this sooner rather than continued escalation. Before you work the steps, do your homework. I want you to have your contract at the ready. I want you to have your time records. I want you to have any communications trails between you and the client about any payment issues or payment agreements or exceptions you've agreed to payment agreements. You need all your homework and your documentation ready before you embark on these steps. Otherwise, you're just going to be spinning your wheels. All right, step one, what we call your first notice or first demand letter. This is usually the first step for you to take after sort of the informal phone calls to AR, or maybe owner-to-owner conversations or owner-to-CMO conversations have not resulted in fixing the problem. It is a letter from the agency to the client that feels a little bit more formal than an email, that includes this essential information. You owe us this much money. You were supposed to pay us this much money by this date, and you haven't done it. This is the contract language that we agreed to, and you point out the actual provisions in the contract that relate based on the facts of your situation. I didn't put it up as a bullet here, but I should have in this slide. We've performed under the contract. We've done everything that we agreed to do. You haven't paid us pursuant to the contract. You need to pay us by this date, or we're going to continue to pursue legal remedies. And you are that non-specific about the remedies you intend to pursue, because the remedies could include additional correspondence, they could include litigation, they could include collections. You haven't decided at this point. So that is your first demand letter. All right, step two, this is your second notice or second demand letter. This is going to have a more stern tone. Again, the goal is not to force you to write like lawyers, heaven forbid, but it's going to start to feel more formal. Some of our clients have had us ghost write these for them, but sent them themselves to their clients. There are more deep references to the facts that occurred between agency and client, problems that may have arisen during the relationship that may have resulted in the client saying, I'm not paying, or disagreements you've had either about the work itself or the amount of fees charged for the work, whatever those might be. A more detailed reference to the facts, and perhaps a deeper reference to particular contract provisions. This is the point, if you haven't already done so, where you want to throw out hey, we own the rights to the work that we've done for you until you pay us. That's what our contract says. You still owe the agency money. We've tried to contact you X number of times to resolve this. you breached our agreement. Plus, as I just said, we own the IP, by the way. Pay by this date. And this date will be a much shorter window than what your first demand would have had in it. I would say the first demand, 14 days is standard. If you've escalated a second demand, you're looking at 7 to 10. Because each additional window you give them adds on to the previous one, and that just draws this out. Longer than you would like to, but it's still quicker than having to litigate it. So this is the second notice. My hope for you is that this will do it for you and that you won't have to go any further. And that is the case for some of our clients. For some of our clients, it's not. And so this is our final pre-suit or pre-collection notice to you. Very short compliance date, like 48 hours to 3 days. You still owe us money. We've contacted you multiple times. Now you're infringing on our IP willfully because we've already told you that we own it. You're still using it. You still haven't paid us. Pay by this date, or we're going to authorize a lawsuit against you for the money. And we're going to hold you accountable for the collection costs, attorney's fees, or any other and here's the provision in the contract that says we can do that. So again, relating back and forth between facts and contractual provisions is your friend in these situations. So this is why having all your documentation and homework in front of you is so helpful, because it takes time to pull this information together, and you don't want to have to continually be doing this. All right. There's some things between the steps that happen. It's not just send 1 letter, send 2 letters, send 3 letters. Ideally, there are conversations or communications occurring in between this correspondence. Ideally, you never have to escalate to all 3 letters, and hopefully after the first letter, you resolve it. But you might decide to escalate after 1 letter to litigation. You might decide to escalate after 2 letters to litigation. You may decide to continue to try to work with the client. And that will depend upon how do they respond in between. They might come back to you and say, we agree we owe you some money. We disagree we owe you this much money, and this is why. Or we don't agree with your expression of the facts. We think this is what happened, and this is why we haven't paid you. So, and we're willing to pay you X, but not Y. There's a million things that they could say to you in between. There's no way I could account for all of them in this session. The point is, they may respond, and that response might either result in a resolution in the form of a settlement, or it might result in them raising some facts or circumstances that you then have to react to in your subsequent correspondence. So the in-between steps could be settlement correspondence, response correspondence, settlement agreement drafting. And I know this sounds like a lot, but I want you to understand what the steps are so that you can understand if the agency has the capacity to manage this internally. A lot of times agencies will say, we don't want to deal with all of this. And I would point out that even if you hand it off to third party, you're still going to have to be ready and available to provide the factual support for what you're demanding. So just keep that in mind. All right, if those steps don't work, and hopefully it hasn't been 3 plus, but if it has, in some jurisdictions, depending upon the local rules and depending upon the amount of money that you are claiming the client owes you, and depending upon whether those local jurisdictions allow an individual to represent the agency, you may be able to bring a small claims suit against them. It's a very simple proceeding. Many of you might have been in small claims court yourself for personal things. You contact the proper jurisdiction. You use their forms to complete to assert your claims. You attach the relevant documentation. The court is going to set a hearing, and you'll be required to go to the hearing and tell the magistrate or the judge why you've sued them, what you think you owed, and why. Again, this is not going to be an option for all of you. You may be owed too much money. They may not allow an individual to represent your agency since it's an entity like a corp or an LLC, or they just don't allow this kind of dispute to be heard. But it is an option for some of you. So, know your options in your local jurisdiction. And cross-check the venue and jurisdiction provisions in your client agreement with these folks. Hopefully you have home court advantage in your contracts before you file. All right, what I call the final frontier, and I'm not going to spend too much time on this because I know most of you know about these options. The collections agency handoff or the collections attorney handoff. Sometimes, honestly, you are not going to have a better option than this. Either the case is too complex or the amount of money involved is too large, or you don't have the internal bandwidth to manage this. There's good reasons to turn things over to collections professionals. I just named a few of them. The trade-off is the contingent fee doesn't kick in unless there's a recovery, which is positive, but it will be higher than what you might pay if you are able to resolve it at the demand stage. So you have to kind of balance whether it's worth it and whether it makes sense to try some of these self-help options before you escalate it that far. All right, I can feel a little overwhelming, but we've got some help for you on the way. We're going to get into your questions in just a minute, but you're going to get the recording of this session. Use it sort of as your checklist or your guide for how to think about handling these things internally. And then I'm so excited about a resource that we have created for all of you that gives you a system to implement in your agencies, to know what contract language to have, and to have samples of the correspondence that you need if you are in this situation and want to resolve it internally. So our agency collections toolkit, something you'll all be learning about at a later point, but its help is on the way if this is something that you want to tackle on your own. And hopefully the Q&A that we get into now will give you some further ammunition to deal with these payment disputes with. So with that, that's my contact information, and I am going to sit here quietly while we wait for questions.
Oh, we don't have to wait. There's quite a few of them in the chat.
Okay.
So I'm just going to start kind of at the top. I've gotten some publicly and some anonymously, so I'm just going to go down the list. So the first one is from Vontavious. She said, how much would a restart or dormancy fee be, or would it be a percentage?
You know, I was thinking about this session last night, and I thought, I know somebody's going to ask this. I may not have a specific a number as you would like me to have, but I would think that the restart and dormancy fee should be a sliding scale based upon the following factors. What is the amount of time that has elapsed since you were actively working on the client's account and when they have, resumed the work? The longer it's been, the higher your restart fee should be. Maybe the equivalent of up to a month's worth of service. Because it's going to take your team a longer time to reacclimate, to re-get into the groove. I would also think about whether there are, missed opportunities that have occurred as a result of the fact that they delayed the project, and whether that factors into the restart costs. Will you have to do discovery all over again? Will you have to reassess the strategy? And those components of a restart, I think, should be priced just as you would price them at the beginning of an engagement, maybe with a slight discount because you know more about the client than you would have known at the beginning. But those are the kinds of things that it's a new ball game. We basically have a restart here, and so we're at square one. So in those cases, I would charge pretty close to your full fee and maybe discount it just for purposes of acknowledging that you already have some institutional knowledge. And then in other cases, really your costs are limited to what the administrative time would be to re-engage, get them set up on payments again, get the work dusted off, and get some meetings scheduled. So it's a sliding scale based on how long it's been and how much work you will have to do to get re-engaged.
Okay. Awesome. Thank you. Okay. The second question is really a two-part question. It is, how many times do we have to contact the client? And then the second part is, are we obligated to tell them that we're taking legal action or we're pursuing legal escalation?
Okay. No, I mean, that's a great question. And the good news is there is no minimum amount of times.
Okay.
You could conceivably, if you wanted to, just sue them or turn them over to collections without doing anything else to try to resolve it independent of those actions. Um, the risk of doing that is that maybe you haven't done all the preparatory homework before, so maybe your recovery is not going to be as strong as you want it to be, and also you will definitely um, impact the relationship with the client, which you may not care about at that stage. But so there's no requirement for the number of letters you've got to send them, the number of conversations you have to have. And there's no requirement to tell a party that you're going to bring legal action against them um, before you do so, unless your contract with the client, and this may be in some agreements that you have with larger enterprises, has a specific dispute resolution mechanism. And for some enterprise companies, there will be one, and you're required. This is how we escalate payment disputes. The parties will make reasonable efforts to communicate to resolve it, et cetera, et cetera. So if there are steps specified in the contract, then follow what the contract says. But there's no legal, outside of what you've agreed to in the contract, there's no legal requirement that you tell them anything before you sue.
Okay, perfect. Okay, next question is, would you recommend a collections agency or a lawyer first?
I would recommend, I think it depends upon the personality and culture of the particular client, but in almost all circumstances, I'd rather see you go with a collections attorney, because I think that um, they will be more open to novel legal most collection agencies are not going to be very open to you pointing out the IP issue, for example. So my preference would be you go to a collections firm. I think they're more likely just to be able to have more options to help you resolve it. That might be bias on my part, given that we are a law firm that doesn't
I
do
was going to
collections.
say, if you said collections agency, like
Yeah,
not
yeah,
a, not a lawyer,
I
I was like,
freely
what are
admit
you?
that. I freely admit it. But, with B2B, sometimes a law firm just works faster. So that's my off the cuff reaction to that.
And then next question is from Jason. He said, Sharon, our accounting software sends up to 3 automated past due email reminders. How soon and at what rhythm should we send these 3 before we send or take a more personalized communications approach?
That's a really great question. I suppose it's a matter of how quickly after the bill is due they go out. If they're automated to go out really promptly, then I would say use the same cadence for your escalation communications. Um, but yeah, that is a really interesting question. Um, if you've sent them 3 notices and nothing's happened, then I think it's fair game for implementing the escalation steps immediately that we walked through here. But if you're getting some feedback, some communication, then maybe use that cadence for the correspondence as well.
Okay, and then Travis has quite a few questions in chat. So Travis, I'm going to pick 2 just so we can get to everybody's questions, and then we'll
Just
reach
so you
out
all know,
to
I'm happy to stay for a few
Okay.
extra minutes. I mean, for anybody else who wants to wait and
Perfect.
Yeah.
So Travis said, what legally speaking do we need to be aware of when considering acquiring another agency?
Well, I'm going to assume, Travis, you mean with respect to their accounts receivable or invoice billing practices. I think the first thing you need to be aware of is how systematized are they? How buttoned up are they about how they write their contracts and procedures around collecting money and their follow up? If they have the same approach to or similar approach to and a similar culture around you, then merging your, and I don't mean merge in a legal way, but integrating your client bases to implement your practices is going to go a lot more smoothly, and it'll be a lot less shocking to their clients when you buy them than if you guys do things completely differently. If you have different business models for how you bill and collect for fees, then the thing you need to watch out for to avoid payment disputes, in my opinion, is to make certain that handoff communications are handled really well with their clients so that they understand that going forward, you might be billing, your approach to billing and pricing is going to be different, perhaps. So, your mileage may vary depending upon how different the two agencies are. But I'm assuming that you're talking about getting together because you have similarities. And so, look at their sample client agreements, look at their history of AR collections. Do they have a lot? Have they had a lot of old receivables in the past? Because that can tell you a lot about what their client expectations are.
Awesome. Okay, and Travis has quite a few other questions that don't necessarily relate directly to this. So again, Travis will reach out and make sure that you get your questions answered and have the time you need to sift through those.
Absolutely.
So the next question comes from Jocelyn. She said, do you have any tips or advice for when a client files bankruptcy and still owes you money?
That's a hard one. And unfortunately, you only have two leverage points here. The proof of claim process for unsecured creditors, which I'm going to be honest, is probably not going to be very satisfying because the bankruptcy court will always prioritize secured creditors of your client before they will trade accounts, which is what the bankruptcy court will consider a marketing agency invoice. But by all means, file your proof of claim because there may be a pool of money to pay some number of cents on a dollar for all unsecured creditors. There is in some cases. Secondly, look at what IP leverage that you have. If you have not been paid and therefore have not transferred the IP, think about, do you have leverage to stop them from using the IP? Not so much because you're interested in filing an infringement lawsuit because they're going bankrupt anyway, but because if they want to continue to operate, if this is a reorganization bankruptcy or they're selling assets to someone who wants to use and operate the business as a going concern, they will or may care that they cannot use the marketing work that you've done for them in the past. So I would look at those two lever points and review your MSA to see if there are any of the additional lever points we talked about.
Thank you.
Mm-hmm. Thanks, Joss.
Okay. The next question, any tips on collecting from a slow paying client that claims a money flow issue? And if you have an interest clause in your contract, how do you put that in place if a portion of the outstanding fee has been getting paid over time?
Well, if you've agreed to an alternate payment schedule for a specific amount of the balance that's due, then you have probably foregone interest as to that portion, unless they're not meeting their payment obligations on that plan. And then you revert back to whatever the contract says. I mean, encouraging them to meet the agreement they made with you for the revised payment.
Sorry, Sharon, he interrupted. No agreement was made. So there's no agreement in place, it sounds like, for that.
Well, then I think you revert them back to what the contract says and start imposing the interest, all of the interest that they would owe. Maybe you reserve, maybe internally you think about waiving it later, but it's the cost of them having your money is significant. And so I would raise that lever for sure. And I don't know how long it's been since they've paid you or how far out of whack they are with their obligations, but I would think about work stoppage. Hopefully you have work stoppage in your contract, but even if you don't, they're not complying with the agreement. So they're kind of breaching the contract anticipatorily. And therefore, I think you can make an argument that you don't have to perform either. I know this is tricky though, if you want to continue to have them as a client. So tread delicately, right?
Okay. Anything you want to add to that? Not you, Sharon. I'm sorry, just waiting in chat to make sure.
That's okay.
Okay. Okay. So how do you determine prevailing rates on interest?
So, I mean, there are usury rates that apply to consumer credit that don't apply to business transactions. That said, in my view, the goal of assigning interest in a professional services agreement is to deter the client from paying you last after they've paid their other bills. So it should have enough bite in it that they will feel the impact, and so that you can be somewhat made whole for the delay in receipt of your funds. So what we typically see is around 18% a year. I would, consult your local state laws to see if they have any different requirements, but 1.5% a month, 18% annually is pretty much the standard in the agency world. I've seen as much as 2%, but not beyond that.
Okay, and then the next question is, I'm going to go back to some of Travis's questions now. So he asked about credit card disputes. How can we win? So Travis, is this pertaining to if they paid you with a credit card and then they canceled it? Can you give us a little bit more context on what you mean by that?
I'm wondering if, Travis, if you mean chargebacks, dealing with chargebacks?
Yeah. Can you guys hear me okay?
Yeah, we can hear you.
Thanks for this, by the way. This has been great.
That is a bear, and it's getting harder to win as a vendor, as a merchant. And this is where doing your homework before you respond to the chargeback is super critical, because the more documentation you can throw at the credit card company about what the client promised to pay, what your contract requires them to pay, and the work that you've done, the more they want to collect interest from their cardholder, which is your client. So the more you can do to substantiate, the better. Credit card companies have gotten more aggressive about permitting the chargebacks, and made it a little bit harder to win, according to what I am hearing. So you've got to pull your homework together really tightly and over explain the facts in as succinct a manner as you can, so that the card merchant understands why they're wrong and you're right, and you are owed the money, and it shouldn't be taken back from you for the work that you've done.
Cool. Thank you. It's like the biggest fraud in small business right now. I hate it.
It's unfortunate, I know, and yeah, small business owners are the ones who are outsized suffering from it. Unfortunately, I agree with you.
So Mike put a suggestion into chat too. He said, can I suggest that for agencies that have out-of-state clients, that the MSA require the governing law or jurisdiction be in your home state? If the MSA jurisdiction is out of state, collection becomes a lot harder and legal action becomes much more costly. So Sharon, can you speak to that, or do you have any recommendations?
I 100% agree. I mean, we write all of our contracts for our agency clients for the jurisdiction to be in their home state. And it's funny that you raise that, because when we are in MSA negotiations on behalf of our agency clients and their clients, this is usually one of the last sort of hills to die on. And a lot of times our agencies will say to us, how important is this really? I mean, and we will tell them, well, if you are sued or have to sue, it will be in the state that the contract says, which is not your state. So this is one of those, infrequent circumstances where that imposes an additional burden on you, which makes the other pre-litigation steps more important to understand and to be fluent in. So yes, I agree with you. Always, your standard default in your contract should be your home state, your local jurisdiction. I agree also that if you're negotiating off of brands paper, they're going to want the jurisdiction to be in their backyard, and you have to decide whether you're willing to take the risk of that happening.
Okay. And then Vontavious asked, could you rename the collections firm or agency you recommend that are contingent fee based?
Oh, specific names of? No, I don't have any specific names to recommend, unfortunately.
Okay, and then I'm just double checking to make sure that nothing was missed.
Such good questions, everybody.
Yeah, the questions have been really good. Let me see. Gosh, chat has been going and going. Oh, and then Travis, I'm sorry, I missed your question up above. What does a collections agency do?
They will be relentless in their reach out and communication with the party that owes the agency money. And the best thing about them is that they're so reviled already that they have the thickest skin around. And so they're tenacious. That's the best thing about them. The other thing that is, I don't want to be dismissive of, is that you're not going to have any costs associated with that in most part, unless they actually recover something for you, but they will take a good chunk, 30 to 40%. So, you have to decide whether you're there yet or whether it's more valuable to you to try to resolve this independently so that you can recover as much of what you're owed and keep it as an agency. But there are times when they're going to be the best option, or you have run out of all the self-help you've engaged in. Yeah, Jason, I agree with you. Jason says that small businesses need advocacy to make it easier to collect from bad actors. I don't disagree. I don't have the policy answer for you, but what I think would help, this is just my personal opinion and a matter of policy, would be more business dispute courts that are sort of running along. And some regular courts have separate tracks of business dispute cases, but they handle all kinds of business disputes, not just collection cases. But I think it would be good to have a business version of small claims courts where you could take business to business disputes there independently of having to have legal representation. Mike, yes, every registrant will get a recording. I'm surprised nobody's asked sooner because that's usually.
Oh, they have. I've been answering.
Okay. Yeah, everyone will get a recording. Everyone will get a copy of this afterwards.
Yes. Okay, and then Travis wanted to ask, how can we have great contracts that are simple for the client so it doesn't delay or hinder a sale on the front end?
Well, think about standardizing your document set so that it's easier to make sure you've covered all these bases if you have done the foundational work, as I mentioned at the beginning of the session, of having a standard set of legal agreements that include all this stuff. So you should have standard MSA that includes all these things when it comes to your payment provisions. It needs a lot of other stuff too, by the way, but we're just talking about money today. That's the easiest way to know that you haven't missed any of these points. And it's also a great checklist, if you will, or benchmarking tool if you are agreeing to or negotiating off of the client's version of an agreement. So, doing the work up front here in drafting agreements and making certain they reflect your policies in all regards, particularly for the purposes of today's conversation, payment policies, is a critical step of self-help. And happy to answer questions offline about what that entails. But there's a reason why, this is one of the fundamental legal pillars that we focus so much time helping agencies with, that we've devoted Q&A time to, and we've created a lot of legal toolkits around these standard pillars and the agreements that go with them. So happy to discuss further offline. Yeah.
Can I ask a follow-up on that?
Sure.
If that's okay. I guess one of the things I've seen with some of these bigger agencies like Red Bloat and stuff is it's like a one pager that's like, here's kind of some standard stuff, one pager, here's what you're signing up for. Then at the bottom, it's like sign here, but it says like you're agreeing to all the terms and services on our website. And so it's basically, instead of them reading 18 pages in a contract that we're currently giving them, it's like, here's simple, you can sign it. Technically you're signing it for over here. Is that like too like shady? So that doesn't stand in court as well versus like, here was your 18-page DocuSign document that you read through and signed and initialed each page.
Super fact specific, so it's hard to answer that at a high level, but the more opportunity the client has, I'm going to stop my share here. The more opportunity the client has to very clearly see the terms up front, obviously the better. But, you know, I don't have an opinion one way or the other. We have many clients who do digital contract signing, and those are just as enforceable. So, again, happy to talk offline about specifics there. And then as to the payment stuff, you're going to get this deck, as I said, and I'm really excited about. I have to tell you all that we've done a number of legal toolkits here at the firm for agencies. We've spent more time putting this one together than we've done on any of the prior versions, and we had a lot of fun doing it. And I feel strongly about giving agencies some self-help tools in this regard because, honestly, a lot of times you need that option that's in between or turning it over to a lawyer or collection on a contingent fee basis, and we're going to do nothing. So we love the idea of giving you additional options. We hope you'll check it out and reach out if you have any additional questions. So you'll get follow-up from us about this, I think either later today or maybe tomorrow. And I'm happy to answer questions once you do.
And Sharon, I suggested when you were going through the 3-part, kind of here's the demand letter, here's this, that, and the other. I said, for us, if we have to do this, we just include a small picture of you with a baseball bat. So if you get the toolkit, maybe you'll get that too. Just create some motivation.
I didn't realize that picture had gotten out there into the public.
Well, it's not everywhere. It's a special privilege that, if you want the toolkit, that's what comes with it. So
I would be happy to pose with a baseball bat with every agency's logo on it. That's something you want to talk about. We will talk about making that happen for you.
Perfect. Okay. I think that is all the questions we have time for today. Sharon, as always, thank you so much. Travis said I would have paid for this meeting. It was of immense value. So Sharon, as always, thank you for sharing your smarts and insights. Always helpful to us, whether we're, looking to monetize or we have to deal with a sticky situation. So thank you so much for your time.
It was our absolute pleasure. I want to thank you all for being here and thank you all for hanging in a little bit past the hour and for giving us grace on the new scheduled date. So have a great rest of your week, everybody. Thank you so much.
Thank you, guys.